take note of that. Yes. I hope there are no questions from where we left yesterday. Is there anybody who needed maybe a bit of clarification on one or two aspects that we discussed yesterday? Okay. So this morning we are going to start with this topic, uadilifu case management system. It will be divided into three segments. That is by the speakers. We will have Lillian to take us through or to give us an introduction of what the uadilifu case management is all about. And then Mr. Victor Mule will talk about central intake. And then we'll have Laila to give us a demonstration of what this system is all about. So it's my pleasure to ask Lillian to start us off. Maybe before Lillian starts, I would like us to take a minute or two to see those ones who have joined us today and who are not here. Can you please very quickly introduce yourselves so that you are not treated as strangers? Gentleman at the back, please patie kipaza sauti.
Hi everyone. My name is Derek and I'm a reporter from kenyans.co.ke and I'm happy to join you finally.
Thank you. Anybody else? Tomika is right here. Maybe she can use my mic.
Good morning, everyone. It's very nice to be here with you this morning. My name is Tomika Patterson. I am one of the resident legal advisors at the U.S. Embassy. I'm a federal prosecutor from the United States working with the U.S. Department of Justice. And I'm looking forward to being here with you this morning.
Thank you very much, Tomika. Karibuni sana, Mombasa. Anybody else? Paul.
Good morning. My name is Paul Achar. A consultant from...
Paul, ongeza sauti.
Good morning. Good morning.
Hey,
Imakataa. No, but I think my voice is loud enough. My name is Paul Achar. I'm a consultant from the UNODC supporting the ODPP. Thank you.
Thank you so much, Paul. Sana. Lillian. Is there anybody else? Oh, there is a gentleman behind there. Bwana Juma, I think you can hear you. Yeah. Karibu sana, Mr. Juma. Okay, I think now we can start. Unless I've left out anybody else. So once again, karibuni sana.
So good morning, everybody, once more. I'm told that before I can start, today is International Men's Day. and we are very privileged that we are surrounded with men around, and we acknowledge you. And I can see you're all smiles. So on behalf of Michael King is suggesting something. I hope the DPP was able to see the sign. There he is. He's trying to suggest something special for the men. He changed. So yeah, it's an honor to be in your presence today in such a special day. And I'm hoping that we'll be able to proceed on well. So my role today is just to give you a synopsis of what Uadilifu is. The system that was developed by our own Kenyans. And the name of the system, Uadilifu, basically means integrity. And it has 5 modules. Please proceed. So Uadilifu has 5 modules. That is e-filing. E-filing is basically how we file our cases to judiciary. And this particular module has since been integrated with judiciary. And on our own assessment, it takes about 3 minutes or under 3 minutes to be able to file our cases. And if you compare that to the time we used to leave our offices, go to the registry, make the queue, photocopy. So we are saying that it has really enhanced access to justice by just filing through the system. So then the next system is what you're calling the document tracking. So this system is mainly between our offices and also our partners, the interagency collaboration. And this is where we are having, for instance, if we are to get a file from the DCI or National Police Service or even the EACC, then we are able to put it into our system, and eventually we are able to track it as it moves within the office. Then there's the case tracking. This is basically on cases that have been filed. So a prosecutor is able to look at the case, the last time it was in court, how many witnesses are there, which application is due for hearing, and it's like a prosecution diary, but an online diary. So then the next one, a very important one, disclosure. All of us know that disclosure is always an issue, especially in court. It's one of the rights that an accused person is entitled to. And so through the system, we are able to do e-disclosure, which is, again, much better than what we used to do. You would photocopy bundles and bundles. I remember one of the cases, we had over 1,000 pages, and you had to photocopy it and then be able to physically deliver it. So through the system, we are seeing that this has really enhanced our job in terms of the disclosure. Then we have, of course, the e-reporting. This is, we are able to know the kinds of cases we are doing. And this will tie in with what Laila was talking about in terms of the case mapping. We are able to know which cases are being handled by which prosecutor, the stages of the cases, and therefore we are able to interrogate how we are doing our work. So what are the benefits? So we're talking about data integrity. And I know yesterday there was a question that was posed, where is this data coming from? So we are saying that through the system, then we are able to maintain the integrity of the data because it has security features, which means that you cannot easily get into the system and be able to alter. And should you be able to alter, then we are able to track the person who's interfered with the system. There's also the data confidentiality. And then integration, if you're able to integrate with the judiciary, which we've done, we integrate with the investigating agencies. And finally, we also integrate with the prison. So we are seeing like it also enhances interagency collaboration in terms of talking to our partners and our colleagues in other areas. So with that, I think I'll be calling Mr. Mule because the case management system has been built out of decision to charge. So basically the features of the decision to charge have been replicated in the case management system. And through case management system, we've introduced what we are calling central case intake, which I'll be calling Mr. Mule to talk about.
So thank you very much, Lillian. So the DPP has issued directions on central case intake. And basically, central case intake is a process whereby all files from investigative agencies are received in the ODPP. And the directions provide for 4 tools. And the first tool is a registry. So there is a central case registry where all files are received. And the second tool is a prosecution clerk. The prosecution clerk receives the file and records it in the third tool, which is the central case intake register. He records it there so that now we have data that we received this file, this particular file, and the details, the name of the accused, the conduct of the investigating agency, the investigating agency, the offense proposed, and all that. After the clerk ensures that the file is complete, and an inquiry file has got about 10 sub-files from sub-file A to sub-file J, and all sub-files are for different topics. For instance, sub-file A is the instance report. Sub-file J is the correspondence between the investigating agency and other agencies, like the Companies Act, the registrar of persons, and all that. Sub-file C is the expert report. Once the prosecution clerk is satisfied that the file is complete, he gives it now to the prosecution, the counsel, who now reviews the file. And now the purpose of reviewing the file is to satisfy himself that there is sufficient evidence either to charge or not to charge. And once a decision is made to charge, it is recorded again in the central case intake register. And now the file goes to court after the charge sheet, after the prosecution counsel ascertains that the charge sheet is properly framed in accordance with the law, and then it goes to court. The purpose of the central case intake is to ensure that we have data and correct data of all files received from investigating agencies and all files where a decision is meant to charge and the files ultimately proceed to court, or where we have not made a decision to charge and we have said there is no evidence, or we have made other decisions like administrative action or to close the file, or further areas which are outstanding to be covered. So we have accountability and we have data out of this central case intake register. Currently, it has been rolled out in Nairobi. It's happening. That's why if those who have come to the headquarters, you see police officers bringing files in the morning. That is part of the central case intake. It has also been rolled in other regions like Nyanza region. Thank you very much. We will be ready to answer any questions on the central case intake procedure.
Thank you very much, Mr. Mule.
So I'm just going to take you all through what the case management system looks like. Okay, this is. Okay, so this is just, I guess, like a dummy website. Well, this is what it looks like, but we can't actually show you the real one because of confidentiality issues. But this is essentially a mock-up of what the site looks like. So when you log in, you'll be able to see the dashboard, which gives you case statistics. You'll be able to see the case files that have been recorded for the day, and then you can see the total case files, cases in progress, conviction rate. These are not the actual figures. And if you want a specific type of report, you can go to the division. Let's say that, and generate, and it should be able to give you how many of those specific cases have been registered for the day. And this would be the prosecution case diary. Essentially, if you're a prosecutor and you have upcoming cases, you'd be able to see when your upcoming cases are happening. So it makes the whole thing super digitized. So what happens after central case intake is that e-filing will happen. So e-filing is essentially, So e-filing is how we then submit the charge sheet to the judiciary, and it will be through this. I don't know if you want me to go through the like all the steps. It's quite long. It's not that long, like takes 3 minutes. But essentially, when you filled out the filing date, the case year, offense, witness type. So here we have confidential, non-confidential, which is really important, especially when it's children. You would choose confidential because you don't give out their names. And then you'd come to the investigative agency section, where you're able to put in who brought the file. Is it EACC? Is it the DCI, CARE, the police? You can put in the exact station. So we have the investigating officer, which is really important for accountability and being able to just track who is handling the case. You'd have the case file number, the OB number, the OB date, and then you'd come and put in the party's information. So you can choose, is it a natural person? Is it an entity? Is it an accused? And party level allows you to input, if it's multiple accused people, you'd put like the party level be how they come up on the charge sheet. So if it's the first one, the second one, the third one, you would choose according to that. Then you'd add the party, witness information, and charge details, what the charge sheet says. So when you end up submitting the details is when it would now go to the supervisor, because for the decision to charge, there are 2 steps to it. So the first step is done at the central case intake when we agree that we want to charge the sheet. And then after it's e-filed, the supervisor will say whether they agree or not. So we have a 2-step process in ensuring that the decision to charge is done fairly. The other bit that we had tracking, as was mentioned. Sorry, the website is quite slow. And what you would do is you would open a file. So if it's a new file, you'd select new file. Type of file, we can say a criminal advisory file. And we could say it's for stealing, fraud, or forgery. So then you'd open the ODPP file. And you'd be able to receive the QR code, which is really important because it allows us to track who exactly accesses any file that we open. So you'll be able to tell whoever scans the QR code on the physical file, you'll be able to tell who has accessed that file, which is really important for transparency and accountability. And then with that FSN number, you'd be able to now upload the documents to that specific file. So we have the e-reporting, which is also part of the system. And it's super neat because, so this is for Makadara. This is the type of report that it would give you. So you can see that from the 31st of August, 2020, we have so far registered 18,090 cases up until today. And you'd be able to tell exactly who did the e-filing. These are the people who approved it and what the charge was and the court reference number. And this helps us statistics-wise because we can now account for who exactly has done the e-filing, what the type of case is, and even the station that it's coming from. Yeah, thank you.
Thank you. Thank you, Leila. Thank you so much. Ladies and gentlemen, you will agree that we are right on course towards becoming a 21st century prosecutorial entity, which will be the envy of many in this part of the world. And you can see that this will go a long way towards answering some of the misconceptions that are out there. And it's important, as we talked yesterday, to know that we have that form, the decision to charge form, which explains everything on why we have decided to charge and also why we have not decided to charge. So that puts to rest the notion that decisions are made at anybody's whims. Our decisions are guided by our guidelines, and we have documentation to prove to that effect. That's as far as our local situation is concerned. Madam Tomika, we are going to have an understanding of how the global perspective of prosecutions looks like. And in this respect, we have 3 speakers. We have Tomika, we have Sharmini, and we have Mr. Agri Juma. Sharmini is on the way. She should be here in the next probably 10 or so minutes. So we can start with Tomika. Tomika is a very integral part of what we do. She's always there whenever we need her. Karibu sana, Tomika.
Can everybody hear me? Okay. So I'll just give you a brief overview of sort of a U.S. perspective on charging, plea bargaining, and diversion, which I know is many of the topics that you've been focusing on in terms of some of the ODPP's new approaches to 21st century prosecution. But I am open to taking any questions. So I'll just give you a couple of highlights, and then if you have any questions, I'm happy to take them. So I'll start off with charging. And I think one thing that is consistent with the way that the ODPP's decision to charge is set up, which is consistent across the world, but in particularly in the US, that the decision to charge lies with the prosecutor. So the prosecutor is ultimately the individual who is going to approve a charge. And in many jurisdictions, and in particular the federal jurisdiction, the prosecutor is the one who actually drafts the charge sheets. So the investigators investigate the cases, and then the prosecutor ultimately makes the decision to charge. One difference with Kenya is that in the US, most of our cases, particularly at the federal level, at high-profile cases at the state level and the local level, it all starts with a joint coordination between the investigators and the prosecutors. So for instance, in cases that I've had with the Federal Bureau of Investigation, when they open up their file, that case is assigned to me as a federal prosecutor. So very early on in the case, while they're investigating, while they are developing evidence against a target, I'm talking with them on a fairly regular basis. Each time they want to take an investigative step, they're reaching out to the prosecutor to get advice. Is this going to be helpful to the case? One of the questions that is asked every single time. Second, if we were to get this evidence, is it going to meet all of the evidentiary standards in order for it to be admitted into court? And then also there's always conversations about what are the particular charges we're looking at, and if these are the charges, what is the type of evidence that we need? And I think that that's probably one of the significant differences here with Kenya, because we work, the level of coordination happens at the investigative stage. I don't investigate the case. Like, I can't go and kick in a door and execute a search warrant. That's what the investigators do. But I'm the one that's integral in the drafting of the affidavits and the applications. I'm reviewing the investigators' applications before they get submitted to the court. I typically go with them to court in order to get all of the legal documents. So it really is a partnering between the investigator and the prosecutor. In terms of how you make the decision to charge, in Kenya, I think you guys may have heard already about the evidential test and the public interest test, those essential tests that are needed to determine whether or not you can charge a case. In the US, we have a similar process. You have to have probable cause to arrest someone, and then you have to have proof beyond a reasonable doubt in order to charge a case, right? So very similar. We don't have a separate public interest test because we consider public interest all the way through. We consider public interest on whether or not you even investigate a case to begin with. So we might end up investigating more hate crimes involving attacks on Asian Americans. That has happened quite a bit in this post-COVID-19 pandemic. So those type of offenses, we're absolutely going to say, this is in the interest of the community. We're going to focus on those cases. So we consider public interest all the way through from the investigative stage up to the stage that we're going to consider charging. But like I said, the decision to charge lies with the prosecutor. And one thing I think is very important and is integrated within the decision to charge process that you just heard about is that we have to have supervisory review. So as a line prosecutor, I cannot make it a separate, independent decision to charge. I have to have a supervisor, if not several layers of supervisors involved in that process. And I think you saw that with the case management system where you have to upload it and then a supervisor has to approve. So that's very similar to the US. And it's an accountability measure to make sure that all of the various elements of the offenses have been met, that all of the possible defenses or arguments about whether or not evidence is admissible has been considered. So it is that second layer of accountability. And then we also have across the US, whether it's at the federal level or if it's at the state or local level, there is an intake process. So standard procedures for the way in which cases are decided. And again, it's to establish an accountability system. The intake process differs depending on what jurisdiction you're in and the location. So in very high crime areas, like your metropolitan areas, those type of intake systems are going to look a little different than the systems that are set up at the federal level or the state level. So I'll give you an example. We'll take the city of Philadelphia, which is where I'm from. The intake process at the federal level and at the local level looks very different. At the federal level, we all operate in specialized units, and all decisions are made within that specialized unit. So I came from the corruption unit. Every case I investigated had to go up to my supervisor and then up another level to a supervisor in order to get reviewed. But everything stayed within that level of reporting. At the district attorney's office, it's a slightly different system. Philadelphia is one of the largest metropolitan cities in Philadelphia, very high level of crime. So they have a 24-hour intake system. Very different here than in Kenya. So if you get arrested, you will get processed out of the system, usually within about 6 to 7 hours. Maybe it can be a little bit more, depending on how many other arrests have happened that day, or a little bit less. But when you get arrested in the city of Philadelphia, for example, if you get arrested at 2 o'clock in the morning, you get processed, and then you appear in front of a magistrate, like I said, within about 6 to 7 hours. There is a duty prosecutor and a duty defender that is working 24 hours. That way there's a good good processing of folks through the system. And then you have other jurisdictions where charging is going to happen, maybe not on a 24-hour basis, but on a pretty regular basis each day. But regardless of what jurisdiction you're in, that charging decision, like I said, lies with the prosecutor. And then in terms of plea agreements, just turning to that one really quickly, the U.S. has been engaged in plea bargaining since the late 1800s. So we have a lot of experience and a lot of time to learn what works and what doesn't work. And at the federal level, just to give you an example of how much we plea bargain in the U.S., at the federal level, the most recent statistics, we resolved 97% of all federal cases through plea agreements. That is actually a real number, not making it up, 97. So if there were 100 cases filed in a day, 97 of them would be resolved through a plea agreement. So 97 of those accused persons would say, there's a lot of evidence against me, it's beyond a reasonable doubt, I'm guilty of this offense, I want to plead guilty, get myself out of the system as quickly as possible, and get potential consideration by the court at sentencing, so I can look at a lenient sentence. So 97 out of 100 would say we don't want to go to trial. And that is great because it cuts down on judicial, prosecutorial resources across the criminal justice sector. In the US, we simply cannot take every case to trial. We do not have the number of, the level of resources to be able to do that. So plea bargaining gives us that added benefit of being able to resolve cases quickly. Now, I just want to take you back to charging. Remember I said we only charge cases that we can prove beyond a reasonable doubt. That's the reason why we have been able to engage in plea bargaining at such a high level, because the extent of our evidence, the quality of our evidence is very high. So if you come in with proof beyond a reasonable doubt, the accused person is less likely to doubt that he or she is going to be acquitted at trial, right? Because the evidence is significant. So that allows for us to plea bargain in 97 out of 100 cases. We only go to trial in about 3 cases out of every 100. So that kind of gives you a sense as to how effective our charging system is in the US. There is one difference that I think is very important or a couple of differences with Kenya in terms of plea agreements. In the US, we can plea bargain in all cases, no exceptions. And in Kenya, you cannot plea bargain in sexual offense cases and a few others. But I think sexual offense cases are a fairly large one because there's such a high number of sexual offense cases that are charged here. So that ends up resulting in a lot of cases not being able to be resolved quickly and having to go through the system. So in the US, we do not have any limitations on what type of cases we can plea bargain in. The other difference with the US that I think is also very important is that we have a constitutional right to legal representation that's paid by the government if a person can't afford it. So that means you have someone who is a lawyer who's sitting with you and walking you through the system. So that allows an accused person to make an informed decision and get that guidance that is necessary. So that's also a piece that's very different here to Kenya. But if you look at your plea bargaining laws, they still are very similar to the US. In the US, you get to negotiate the prosecutor and the accused person. They consult with the investigator and victims. And then the court serves as a neutral gatekeeper, deciding whether or not that plea. That is, in fact, very similar to the process that you have here in Kenya. One thing we do have that's a little different, and I think it's important to say what this difference is in Kenya you can submit on sentencing. You can give a recommendation. So the prosecutor and the accused person can say, hey, we think that the probation would be a great sentence, right? And it stays within the discretion of the court. In the US, it's very similar. We can make recommendations at sentencing. But we also have some laws at the federal level, and I believe across some of these states, where we can actually impose and negotiate a binding sentence, one that the court has to accept. But I want to qualify that with another difference with the US. We have something called sentencing guidelines that helps guide judges by letting them know that if someone with this criminal history commits this type of offense, then this is where generally similar individuals are going to fall. And so those sentencing guidelines are very, very helpful to ensuring that there's consistency in sentencing across the country. So I think that that is a very important point that differentiates the US from Kenya. But on average, the framework for plea agreements is pretty much the same. And then finally, for diversion. Again, diversion has been happening in the US for over 40 years, and we have very different types of diversion. You heard about diversion that is being led by the Prosecution Service here in Kenya. In the US, we have diversion that operates at the court level, at the prosecution level, at the police level, and we even have diversion that happens at the community level. So some examples are, we have specialized courts. So if you are suffering from mental illness or drug use, if you are a first-time domestic violence offender, or you are a veteran and you have been a level, and I think that that's really, really important, because you want to be able to catch opportunities to rehabilitate individuals across the spectrum. So if you only catch them at the court, that means they're already coming into the system. If you catch them at the prosecution charging stage, that's a way for you to catch them before they come into the system. Even better, if you catch it at the police stage or in the community stage, you really get to engage in some rehabilitation at a very early stage. So I think that that is some good news coming out of Kenya as it relates to the Children Bill. So that's just a short overview of sort of the US perspective on charging, plea agreements, and diversion.
Thank you very much, Tomika. Now, this being a panel discussion, Tomika, please take your seat over there. So you are free now to engage. And to take us through this session, Mr. Mule is here.
Thank you very much. Thank you very much, Hassan. And as you know, the theme of this forum is the 21st Prosecution Service, and that's why we have our panelists today to talk about the international perspective. And you are free to ask questions, but for a start, let's start with welcoming Sharmini, and as she introduces herself, she talks about, after introducing herself, what are the options available to an accused person in terms of you have been presented before court. What are the options available? We are seeing so many applications, thereby occasioning delays. What is the perspective in the international forum where you have worked? Karibu.
Thank you very. Can you hear me? Okay, thank you. Thank you very much. Is that working?
Yes.
Okay. Yeah. Okay. So my name is Sharmini Jayanathan. I'm the Global Prosecution Advisor for the United Nations Office on Drugs and Crime, and I think it's extremely important that the media and certainly those players in the criminal justice system sometimes get together, as we are doing today, to exchange notes and understand how each other addresses the issue of the criminal justice system. I think many people are very rude about the Fourth Estate and the role that you actually play and the power that the journalist world has in terms of its power to both destroy and elevate the institution. Now that power, as you're exercising it, obviously is in the context of criminal justice. I would simply say this. Every single one of us is impacted by the rule of law. In every bit of our lives, every smallest aspect, the functioning of a strong rule of law, particularly in the sense of a criminal justice system, is vital. And unfortunately for many of us, unless we actually need it, we don't know about it. It's a little bit like healthcare. Until you know that you need healthcare, you don't think too much about it. And unfortunately, in many ways, the criminal justice system is the same. Until you are a victim of crime, or a witness to a crime, or you are accused of a crime, often in circumstances for all three, a bit like when you get sick or are run over, it's very distressing, and it's only then that you realize you need a functioning, and that it requires the same investment and support as you would demand of your medical and health sector. So when it comes to prosecutions, I see a lot of similarities in the way that Kenya has undergone its journey to what the UK did. As a British barrister, it was in my lifetime that police brutality was not uncommon, and that they went about their business with impunity. And we've seen that even here in Kenya with the recent convictions, that's actually starting to change. It wasn't very long ago that in the UK, the Crown Prosecution Service didn't even exist. An independent prosecution authority didn't exist. It only started in the 80s, a bit like the ODPP has now started here in 2010. And as in the UK, police prosecutors handled all criminal cases, just like over here. And just like over here, the UK phased them out over a certain period of time. It's not perfect in the UK, but there are so many similarities in the journey, and that is what I would invite you as the media to remind yourselves of. This is a journey, and you play an incredibly important role in emphasizing the rule of law and how it operates in order to increase and improve that sense of justice and security for everybody, and to ensure transparency and accountability. Now, when defendants appear before the court, sadly, many of the options that are available to them will really depend on whether they're represented or not. Legal aid is incredibly important to the efficient functioning of the criminal justice system. And I know that as a prosecutor, whenever I walked into court in the Crown Courts of the UK, if I saw an unrepresented defendant, I would groan quietly, because I knew that my trial was probably going to take 3 times as long. We weren't going to be able to agree anything, because I couldn't have that conversation with him without the perception that I might be somehow influencing him or taking advantage of his ignorance. And so the wheels of justice would then turn ever more slowly. So having legal aid in a healthy criminal justice system is vital. And unfortunately, in many jurisdictions across the globe, it's still seen as a nice to have until you're in the system. And then you desperately, desperately want it. So in other jurisdictions also, I would say this about prosecutors. The role of the prosecutor has not really been recognized fully in international instruments. It wasn't until the Havana Convention, it's known as the Havana Convention, I think back in the 1980s perhaps, that the role of the prosecutor was given some sort of international recognition. Then the International Association of Prosecutors was established in 1990, and that bolstered that convention with additional guidelines on how prosecution authorities should function. And I see a lot of those guidelines being adhered to here in Kenya as the ODPP makes these enormous strides in such a short period of time. After all, I came here in 2012, there were only 160 prosecutors. In that short period of time, we now have, I think, over 800, which is an incredible sort of sense of progress here in Kenya. And I think a recognition that here in Kenya, there is an acknowledgement that the criminal justice system must work better and more efficiently for everybody. Internationally, there are different systems, obviously. In civil systems, you'll find prosecutors play a much more proactive role in investigations. They may turn up at a crime scene. They may actually give instructions to the police. In many jurisdictions, the prosecutors are counted amongst the judiciary. So they have the legislative and procedural protections of independence the same way that a judicial officer has. But in jurisdictions like the UK, we're not in that same boat. We don't direct investigations. We don't turn up at crime scenes. We might guide an investigator. Certainly as a prosecutor in the UK, officers would come to me for advice. I would give them the advice. If they didn't take it, there really wouldn't be much more to do on that case unless we received a complaint from a victim or witness, and that might generate a process in which a review would then be undertaken. Another key important thing to note about prosecutions and the decision to prosecute is very often in many jurisdictions, the decision to charge is not appealable. It's not subject to review, but the decision not to charge may be. And that's very important in terms of protecting the rights of witnesses and interest groups, communities who may be disturbed and not understanding why a decision to charge has not been made. Having those avenues for that decision to be reviewed and looked at objectively is very important. And in the UK, we do this through CPS, Crown Prosecution Service scrutiny panels, and we have internal reviews upon receiving a complaint from a victim. So that's very important also in terms of building accountability and transparency. I'll just say this about the role of the prosecutor. The prosecutor stands at the gateway to the criminal justice system. It is the prosecutor that determines whether this case or that case is going to be fed into that criminal justice system. And I know my colleague on the left here is going to talk about the decision to charge and how that decision is made. But I think we can say that in all jurisdictions that I work where prosecutors are applying this important power that has the power to change the lives of civilians, of ordinary members of the public, it is not something that is wielded without care or without concern. And because, as in Kenya, as in the UK, as in so many jurisdictions, this decision is codified, it requires a written review, it requires accountability and transparency. That in turn is very important. It's very important that the public also understand how that decision is made, because otherwise we're all operating blind. They don't understand why something has happened, and it's very easy to make accusations of corruption or undue influence. But the gateway position of a prosecutor is something, it's a very heavy burden actually to bear for most prosecutors. And having sat in the back of courtrooms all across Kenya from 2012 to now, I have seen prosecutors going into court and facing multiple trials listed in one courtroom in one day, with courtrooms packed full of witnesses and victims, none of whom they have the time or the capacity to give the real care and attention to. I've seen prosecutors being asked to make decisions on a file by a police officer literally tapping them on the shoulder while they're on their feet on another case, not having the time to really review that case. And I've seen prosecutors having to make decisions without access to the law, with a faulty internet connection, trying to scroll through complex statutes on their smartphone. Those are some of the challenges that I think it would do well for the press to go and see for themselves and understand better as they are dealing and hopefully reporting objectively in terms of how these cases proceed. And I'll end with this particular point. There is a reciprocal relationship between the press, between the fourth estate, and in particular the judiciary. Your obligation as the press is to report objectively, report the facts, and report with knowledge and understanding of how these things are operating. And equally, the judiciary is there to protect you, because the journalists, as we know, are vulnerable to pressure, intimidation, violence. There are some very brave journalists who stand up and take those risks. Ultimately, when things go wrong, it is going to be the court system that you must rely on to enforce your right to report, your freedom as the press, and to bring the criminal justice system to bear upon those who would infringe or violate your right to a free press. So I'm very pleased that this interaction is happening today, so that everybody can get together from these two important parts of the government, well, not the government, but we call you guys a fourth estate, to exchange notes and enhance the understanding, and most importantly, so that you as the press can better report with an understanding of how these things and how these decisions are made. Thank you.
Thank you very much, Sharmini, for that introduction. You have talked about prosecutors being tapped on their shoulders while on their feet in court to make their decision to charge. Tomika, what's your take? What happens in the US? Tell us more about the central case intake. What happens? Are we doing the right thing? What is the international perspective?
So I'll tell you, in the U.S., in most jurisdictions, we are not allowed as prosecutors to make decisions on charging while we're in court on other matters. That's the reason why you set up an intake process where there are duty prosecutors whose sole responsibility is to review a file and make a decision on whether or not there's sufficient evidence to charge. And we've evolved over the years in the US. I think it's the same as the UK. We started out with a system that didn't look like that, where people were going into court and tapping on the shoulders of prosecutors. But it took time for us to understand that that process was not upholding the constitutional rights of accused persons, because it placed too much pressure on prosecutors to simply sign off, because honestly that was the easier thing to do. So instead, we now have intake units. And the intake units are responsible for accepting a file from an investigator's office, and then reviewing that file, and then working with the investigator to identify holes within that investigative file, to provide instructions on what needs to be further looked into, and then ultimately lead to the decision to charge by the prosecutor. And as Sharmini mentioned, in the U.S., there is levels of accountability at the intake stage. So like I said previously, a line prosecutor is not able to charge a case in and of him or herself. It has to then be reviewed by a supervisor, if not another layer of supervisors, depending on the complexity of the case. And that ensures that there isn't any sense of corruption within the system. And once those decisions are made, one additional point that we do in the US is we are constantly reviewing our decision to charge. So yes, you will make a decision to charge at that initial stage, but just as it happens in Kenya, the evidence changes. Sometimes the evidence changes over time. And a prosecutor can reassess a case and realize they have evidence to charge another offense. So guess what you'll do? You'll amend your charge sheet or your indictment, that's what we call it at the federal level, to recognize that there are other offenses. And sometimes you are going to withdraw a case or withdraw some offenses. And so I also think that that's a critical role of a prosecutor, is not just to charge a case, but then to constantly review that decision. And that is something that is built within the ODPP's decision to charge guidelines, which I think is critically important in respecting human rights and constitutional rights that are accorded to accused persons.
Thank you very much. My brother from IJM.
Yes.
You worked as the journey on the decision to charge guidelines. Please tell us about the journey, why it was necessary.
Yes.
And
Thank you.
introduce yourself first.
My name is Agre Juma from International Justice Mission. And as an organization, we've been honored to walk the journey of the decision to charge policy with ODPP. And it is, of course, a mandate that is constitutionally provided for. And so with the coming of the 2010 Constitution, the office of the ODPP was created. And therefore, with that creation, there was certain powers that this office was granted. And so a lot of the decision making around the decision to charge used to previously happen with police officers. And even after the Constitution was promulgated and the office of the ODPP was set up via an act of parliament, there was still a lot of police officers making the decision to charge and some even prosecuting. And so when the office was established, formally, I think it was 2010, 2011, there was the concern around the issues of replacing or adding to police officers, advocates of the High Court of Kenya, to participate as prosecutors. Now, for us as an institution, we work in the community, in the slum communities in Nairobi and the poor communities across the country. And one of the things that became apparent to us was that there was a lot of young men and women who were being arrested and charged over offenses that were not backed by evidence. And so a lot of our work was targeted on representing these people. And sooner or later we realized that we could not represent them all. There were so many. And two things in that season were very disturbing to us or concerning to us. One was the decision to charge that was being made. It was like part of investigation. And so the end of investigation in that season was the charge sheet being filed in court. Now, what this did is that so many cases were finding themselves in court without sufficient evidence. And for the petty ones, a lot of the community members used to plead guilty and just go away as a result of that. But for the more serious ones, there were so many people who found themselves in remand for offenses that they knew nothing about. And so as we looked at the casework that was before us, we realized there was a problem, because the Constitution mandated this new office to prosecute. Yet the decision to make that to do that prosecution, the decision to charge, was placed elsewhere by practice. And as a consequence, I think with discussions with ODPP, and of course ODPP also thinking about it and how to go about it. I think at that time, the advocates had not been hired en masse. And therefore, it was not an easy thing to do, because you still need the police officers, as there cannot be a gap. And so with the onboarding of new prosecutors from 2011, 2014, 2015, now this became a reality, because now we have prosecutors, we have qualified professional advocates making the decision to charge. Yet at the same time, we have a police service that knows that the end of our investigation is filing a charge in court. And so one of the early discussions, and I think in the induction training of 2014, 2015, Sharmini was there, she kept saying, we need to have, together with Madam SPP, we need to take over the decision to charge in such a way that we are not just coming to prosecute as a formality, but we are prosecuting cases whose evidence we have assessed and we've determined that they are good cases for court. And so in 2015, a baseline study was conducted just to see what happens around the issue of decision to charge. And one of the things that became apparent is that despite the office or the directorate having advocates who are capable of assessing the evidence and making that decision, it was not happening. A lot of the prosecutors were just coming to court to meet cases, as Sharmini has adequately stated. And so from that baseline, we identified that there was no recording of that decision. And for a lot of the prosecutors, they had just given in. And they were saying, for us, we'll just prosecute. We don't want to, make the relations between us and investigators or law enforcement to be worse than what it is. Now, the effect of that was that there was a lot of cases, serious cases, that were coming to court, clogging the system, and ending up in acquittals. And this was because the evidence was never assessed in the first place. And in 2017, the National Council on Administration of Justice did the criminal justice audit. And one of the things that they identified was that there was a lot of cases, serious cases. Basically, the conviction rate in serious cases was very low. Yet the conviction cases in petty and traffic offenses was very high and informed by pleas of guilt. And so based on the baseline study of 2015, which was an ODPP project, as I've said, for us, we were honored to accompany. Discussions were going on as to how to go about this issue. And so in 2018, when the new DPP came, I think it was one of the first priorities, because by August 30th of 2018, a gazette notice was issued setting up a task force on the decision to charge. And we said this is something that we would want to partner with and to see how we can work together with ODPP on. And so this task force was a very inclusive one. And of course, at that time, reading the letter of the law, we did not understand why a mandate that is very much clear within ODPP was involving a lot of other stakeholders, because we had all law enforcement agencies as part of that task force. We had EACC, we had EACC, we had IPOA, we had NPS, we had DCI separate, and a lot others. I think the task force had over around 20 different institutions represented, including the office of the AG. And as I said, for us as IJM, we sat down and we were like, they didn't have to do a task force, but they've done it, and it's very inclusive. And so the task force embarked on its work, and its work in the initial stages was also very inclusive. I remember in one of the meetings, there was representation from as many as, I think, all the commanders of traffic from across the regions, as well as NTSA and other actors who had a stake in the decision to charge. The only exception maybe was judiciary. And for them, I think they said they don't want to be involved because of their own reasons. We felt that also was a bit misplaced, because this is a policy level issue. And it affects the work of judiciary. And so they should have been involved as well. Nevertheless, they were not. But what happened is that after a series of different engagements with stakeholders, including communities, and I think in that season, we visited a lot of communities, just doing community dialogues and sharing what the plan of the office of ODPP was. We went as far as Lamu. I've never been to Lamu, it's quite far. Before that, I'd never been. In that season, I did. And we went to 7 of the islands, just sharing this thing. And in that season, I think I served as the rapporteur for some of those meetings. And I remember wondering, why would they concern themselves with sharing with this community the importance of this decision to charge? Yet to me, it felt like it was a very high-level thing. But the truth is that it is a decision whose impact touches on every corner of this country. We were in Kayole, at some point, and I think in this year, we've seen the office of the DPP going back to these places to give feedback on some of the questions that were asked. At some point in that space, the office also brought on board a consultant to assist with ensuring that the good practice across the globe was also infused into this process. And Sharmini here played a key role in that. And by the time we were having an initial draft, we were very happy that it was something that borrowed from best practice globally, but also was highly contextualized as far as the work that ODPP does is concerned. But even after that, there was still a lot of focus group discussions with prosecutors across this country just to give input, to say, this is what you've written, but this is what happens in practice. And so this document was very heavily contextualized into the practice that obtains in our courts. And so by the time we were coming to the point of launching it on 28th of July, 2019, it was something that had taken a number of years to develop. And of course, I think now that the fourth estate is here, I think one of my disappointments when I read the news, the newspapers the following day, was that the guidelines themselves did not take the day when it came to news. What took the day was who attended and who missed. And for me, I think I sat in that and I saw that and I was like, we should have done a bit better. But nevertheless, it's a good document. It is a product of a very inclusive process, and it is one whose implementation should be one that leads us to a better place in terms of making the decision to charge, and whose implementation should also leverage technology for us to be able to maximize on it. But generally, I think in summary, that's the journey, if I'd say. And we are very thankful as an organization to have been invited to lead on this.
Before we open the floor for questions, the role of prosecutors in investigations, the UK and US perspective. We can start with Tomika. US perspective, the role of prosecutors in investigations.
So I already mentioned before we sat down here at the panel about the fact that in the U.S., the prosecutors work in coordination with investigators at a very early stage. So once a case gets open at the investigative stage, there's always advice and consultation with the prosecutor as to each step of the investigation. Just as Sharmini had said earlier, prosecutors are not out investigating, right? We're not typically the ones who are executing search warrants. And I will tell you, rarely do federal prosecutors show up at crime scenes, because the last thing we want to do is to become a witness. And that typically is something that could happen. But what the role of the prosecutor is at the investigative stage is to provide that advice, that legal advice, as to whether or not the way in which the investigator is gathering evidence is appropriate and legal, if the evidence is going to be sufficient to help make that decision to charge. And most importantly, and I think this often gets lost within the discussion when you think about investigation and prosecution being in a silo. In the US, when an investigator finishes their investigation, that is not where they stop. They work hand in hand with the prosecutor in order to bring that case to trial. So one of the key things that the prosecutor is engaging with the investigator on during the investigative stage is whether or not I can prove this case at trial. Is the evidence you have going to be admissible? Is this evidence going to be deemed relevant by the court? There's a number of considerations that the prosecutor is going to think about that maybe the investigator is not. And my job as a prosecutor is to make sure that I can secure that conviction at the end of the day. And so I want to make sure that I am guiding the investigator along that process. And in other jurisdictions where there might not be the ability to engage at a very early stage with investigators, where the investigators bring the case to the prosecutor for the decision to charge, there still is coordination between the investigator and the prosecutor throughout that process. But I do want to say that, I think Juma makes a really good point about the role of digitization and just technology. Part of the reason why the ability for the prosecutor to work closely with the investigator is that we do have a duplicate copy of the file. We make a copy, whether it's hard copy or electronic. Doesn't matter what jurisdiction you're in, federal, state, or local. A prosecutor is going to have the exact same thing in his or her file that the investigator has. And that is what also allows for that open dialogue and communication. So if the investigator calls me up and says, tell me what you think about the evidence, I literally am able to look at the exact same documents that he or she has. So I think that also plays a critical role in the relationship between the investigator and the prosecutor. The investigator's file is open to me as the prosecutor, and I can ask as many questions as I need to in order to help them put together the strongest case possible.
Thank you. UK perspective.
So in the UK, it's very similar to what Tomika has described. Forgive me if this has already been covered, but for those of you who don't know, a criminal offence is something that sits in a statute. It's got to be on a law book, on a regulation. And every criminal offence has a number of ingredients. And when we're talking about the decision to charge, what a prosecutor is effectively doing is saying, are all the ingredients here? And if it's not, a bit like a cake, it's just not going to work. And so when we are talking about prosecutors and investigators, the role that the prosecutor in the UK will play will be to point the officer towards saying, look, this particular ingredient is not fully established, or the evidence that you've got there is not admissible. Go and find something else or rectify the problem. And so that is what the decision to charge is all about, is making sure all the ingredients are established with credible, admissible evidence. Now, in the UK, we have provision for pre-charge advice. So where an officer has, for example, conducted an investigation, hasn't even got round to arresting the suspect yet, but wants some advice about when we do arrest him, what should be the lines of inquiry in an interview, which, by the way, are digitally recorded in the UK, and that is an incredibly important development and incredibly helpful for prosecutors. He can ask for advice. What do we need to ask this guy in order to satisfy the evidential test? They can get, obviously, the pre-charging advice in terms of what are the appropriate charges. He can then come and get post-charge advice, where sometimes we may charge a case in very exceptional circumstances where not all the ingredients are there, but we know we're going to get it in a reasonable time. And if we don't charge him, this person is such a bail risk that we can't risk it. We have to charge him now and go and get the evidence later. But that's very rare, and you have those same provisions here in Kenya. So that's post-charge advice. And then we very often have a pre-trial conference in the more complex cases. So are the exhibits ready? Are the witnesses lined up? Have any problems arisen? Another really important thing that prosecutors will do in the UK relates to the issue of disclosure. Very often, we all probably know, when you're facing a trial, you're entitled to disclosure of the evidence that the prosecutor is going to rely on. But very often there's material in a file that you're not going to rely on, but that might undermine the prosecution case or assist the defense case. What does a prosecutor do with it? In that scenario in the UK, an officer will review that material himself, and sometimes it can be, I don't know how many boxes that could fill this room of unused material. He will flag on a schedule what he thinks this is a bit of a question mark. The prosecutor will then review that information and make a decision on whether to disclose it or not. An obvious example would be where your main prosecution witnesses has a string of convictions as long as his arm. It's not relevant to the actual issues in the case, but it has an impact on that witness's credibility, doesn't it? Should it be disclosed or shouldn't it? Of course it should probably be disclosed. But that is a decision that a prosecutor might make in a discussion with an officer. The interaction between prosecutors and investigators, that early engagement, is always, in my experience, what leads to a better outcome. In Somalia, back in 2012 to 2013, I can't even say Somalia, I would say Mogadishu. The Attorney General passed similar guidelines to what we have here. It's not as in-depth, not as detailed, but it captured the essential elements that you have here. Almost overnight, those prosecutors reported that the number of cases that they were charging almost halved, which means less rubbish clogging the courts, means less delay in the courts. And the quality of the directions that they were then able to give to an investigator improved quite dramatically. Because when you look at the decision to charge and you're working with your investigator and you're applying that approach to every ingredient of an offence, that decision becomes more of a science rather than an art. And that is what means that those directives and that interaction with investigators becomes so much more impactful and efficient. The final thing I'll say about the UK is we have something called CPS Direct. The Crown Prosecution Service offers charging advice 24 hours a day. So from about 9 to 5, you have your centralized case intake. Prosecutors are at their desk, cases are coming in, they're reviewing them digitally. Officer might be on the end of the phone, the officer might be in front of them, and they're making that decision in real time. Come closing hours at 5 o'clock in the afternoon, what's called CPS Direct takes over. These are prosecutors who've elected to work at night from home. A secure line is set up, secure communications, they have a sort of secure computer. From 5 p.m. until 9 a.m., they're on the phone. And so if an investigator conducts an arrest, he wants a good charging decision before he takes that suspect to court the next day. That prosecutor is able to sit, digitally look at the same file, make the decision, endorse the file, give advice on whether we should be opposing bail or not. So that by the time that officer turns up to court in the morning with that file, with the suspect who's been arrested and remanded overnight, that file is effectively ready to be charged. And just like Tomika said, we have a very high rate of guilty plea because we only charge the cases where all the ingredients are there. And that means that there's very little wiggle room for a defendant to play the system because he knows the evidence is there. And what we want to get to in this position with engagement with officers and applying the decision to charge guidelines is that when a prosecutor makes that decision, he or she should almost be ready to go to trial the very next day, subject to witness availability. That's where we want to get to. And for a lot of cases in the UK, that is where we are. Guilty plea rates are very high. It's also very important to mention that those guilty pleas are incentivized. If you plead guilty at the first appearance, under law, you get a third off your sentence. So that sort of development in the rule of law and the sort of statutes that surround the way in which the criminal justice system function, it can be extremely effective as well at incentivizing cooperation, incentivizing guilty plea, so that only ultimately the cases that really deserve a fight in the courts actually get there.
Thank you, Sharmini. And Tomika will come back.
Good morning, everyone. Good morning, everyone.
Hello, hello.
Hello. Not what you expected.
Thank you very much. Tuko kwa hewa? Tuko hewani, eh? Thank you very much. Probably an observation, and any of the panelists can take this. From what I heard, there was or there is a tendency to be casual in approaching prosecutions. You know, where you said somebody can just tap you. Oh, you can. Eh? Oh, nisimame. Higher. Now, this can, any of the panelists can take. I'm just wondering, how many live files or live cases can one prosecutor take at any given time? What is the ratio internationally, and what is the ratio in Kenya, and what is recommended? Thank you.
inaongea hapo. Hapo.
Just shout. It's not on. It's not working. Just shout. Ongea.
Shout.
Mic test on.
Hello, hello.
This red light's flashing now. I don't know if the battery's dead.
Of course I can.
Mic test on.
Ongeza?
Is it? Hello? Hello?
Mic test on.
Hello? Oh, thank you. Thank you, Tomika. Thank you, Sharmini. Thank you, Agri, for your presentations. But just a clarification
Mic test.
on plea bargaining and proof beyond reasonable doubt. At what stage do they take place? We are in agreement whether they take place after you file the case, which means the system in the court, the court system gets clogged, or is it done before? And on the issue of proof beyond reasonable doubt, is that a decision that the ODPP or Director of Prosecutions anywhere makes, or that is a decision that a court will finally make? And the other thing I want to talk about, which is our local scene in Kenya, I don't know the levels of recruitment. When you have an investigator, the assumption is that you're talking about a police officer. I don't know the qualifications to join the police force in the UK and the US, but we have a situation where you're encouraging people who may not have done very well at all level to apply to join the police force. They become the investigators. And then on the other hand, you have those you insisted must attain very high qualifications to become lawyers and finally prosecutors. How do they then work hand in hand? Thank you.
Hello. Frank, utanisamehe kwa sababu we have to flow with the language. Kila mtu anazungumza Kiingereza kingi kwa hiyo. Now, perhaps we have heard for many times that a lot of comparison and examples from the US and the UK. So now,
Thomas.
you know, this thing, no, you can hear me, I think. You can hear me, it's okay, you can hear me. Yeah, I say, we've had a lot of comparison and examples from the US and the UK on the decision to charge by the prosecutor. Perhaps if we could hear also stories from Kenya, Mule, so that, you know, what happens when, say, the courts say that the case is bungled because of lack of evidence from the prosecution.
Thank you very much. My questions are to Tomika and Sharmini. Sometimes when you're watching and listening to international media, you get the feeling that there is no restrictions as to what they can comment on when it comes to active cases. Sometimes they give opinions, they probably tend to give directions on how a case would go. So how does that affect you as a prosecutor? Because when it comes to Kenya, sub judice is a huge restriction as to what we can cover and comment on when it comes to active cases. And then in addition to that, how then do you navigate through different interests, the interests of the media, the interests, or I mean the interests of the editors, the interests of other media players like the owners? How do you navigate through those interests? Thank you.
Well, my question is, there is another school of thought. I think any of the panelists, even from the office of the ODPP, can help. There is another school of thought, especially for us who go to court and report from courts. Who really makes the decision to charge? Because from the investigations, if a police officer starts investigating and finds that there's evidence, but then they don't want to take this person to court, Now, who will really make the decision to charge this person? Is it the ODPP, or is the decision made at the investigation point where the investigator decides that I have evidence against this person and I will take this person to court, or I have evidence against this person, but then there's a way we can work so that this person is not charged. And then actually it goes hand in hand, usually asked. Now when the case goes to court, you find that the magistrate will rule that the investigations were bungled up. Maybe the ODPP, the office of the DPP, feels that this person should be charged, but the investigating arm feels that we should not charge this person. And then it goes, the second bit of it goes to, someone talked about a prosecutor being in court, and then someone taps the prosecutor at the back and says that there is a case. So who should ideally register the cases is in court? Is it the investigating officer? Because we've had instances where someone is brought to court, the file is not there. The police say that, the investigators say that we have the police file, but the person from the ODPP says that we've not seen the file. The ODPP is the one who's supposed to prosecute, but they are saying we've not seen the file. That the police investigators, they have the file in court. So who ideally should register the prosecution file in court? Thank you. Thank you very much. Now let's allow panelists to respond.
Okay, let me start with the last one. You ask who really makes the decision to charge if, in effect, investigators, in the presence of evidence, can choose not to submit these files to ODPP. That in itself is abuse of power. It is police corruption. If in the presence of evidence, you're not recommending charges to ODPP. The practice is that investigators recommend, then prosecutors decide. And so that recommendation should be a formality where there's evidence that indicates a crime. Now, in institutions such as EACC, they do not have that option. So whenever they've compiled an investigative file, whether or not they feel it should proceed to prosecution, they send it to the office of the DPP so that that decision is made, and there's no space to determine that this one, with or without evidence, should or should not be sent. So they send all case files to ODPP for determination. And so if we have a situation where that is happening, that is a situation of police abuse of power. And it is something that should not be acceptable. Let me just take with the other question. Okay. No, there was another question that I want to answer. Okay. Yes, the issue of the launch, my disappointment that we did not cover so much the guidelines, and instead maybe we covered a lot of who attended and who did not attend right in the middle of COVID. And you asked who are the parties in the task force. So the task force was highly inclusive. We had NPS, a representative of the office of the IG. We had the office of the Attorney General represented very consistently. The EACC was also on board. IPOA, and I think this Gazette notice is public. I can find it and maybe send it out. And then there was DCI separate from IG, also represented. ODPP across the different ranks in ODPP. And then judiciary was invited. They declined the invite for their own reasons. And as I said, it's a policy-making process. And so at policy level, there are no issues of conflict of interest or something of that nature. We are creating a guideline that will guide the process of accessing justice. And so it is something that, in my opinion, should have involved even an institution as critical as the judiciary. But yes, it was a very inclusive process. They declined. Yes, they declined.
There were quite a few really great questions there, so I'm just going to dart around on many of them. On qualifications for the police in the UK, you now have to have a degree. The police will sponsor you to do an apprenticeship on a degree program so that you can qualify during your apprenticeship. And there is a fast track program to become a detective where you can qualify within 2 years after that. So I think there's a recognition there, as you've described, that there is a need for a level of education at least, because as I've described, all of these offences have ingredients. They all have to fall within the law if they're going to be admissible. And so that is where we are now in the UK. All police officers must have, in the new recruitment, must have a degree or be admitted onto an apprentice program where the police are funding them to achieve that. When it comes to the press, in the UK, we engage with the press through quite carefully managed press releases that might be issued by the police or the CPS on an investigation. But once a case is charged and within the remit of the court, the media is very heavily restricted. They may report factually on the progress of the case, but they can't be offering opinion on whether this witness was any good or what they think should happen. Don't forget, in the UK also we have jury trials. So these are members of the public. They are perhaps arguably more susceptible to influence and media stories than a seasoned magistrate or judge. So the media there has to be extremely careful about what they report, or they will be held in contempt of court and face prosecution. When it comes to navigating different interests, but as a prosecutor, when I was in court in the UK, I just maintained total objectivity. I didn't have to navigate anything. My only decision was keep the case under review. If the situation changed such that my evidence no longer stood up, and that can happen, witnesses don't turn up, they become hostile, the evidence doesn't quite mount up to what you think it is, you keep the case under review. And sometimes I've had to pull a case halfway through after it started. In terms of caseload, there's no international norm. What I will say, as somebody who's both prosecuted and defended in the UK, when my trial started, it continued until the end. So my caseload for 6 weeks or 3 months or 2 days was that one case. In the background, there may be matters that I would have under review, but that number could vary quite significantly. And if I was involved in a heavy case, that would probably be lifted by the supervisor to another prosecutor. Because when you have an objective decision to charge, and every prosecutor is under an obligation to keep a written review of all of their decision, one of the side effects of that is that before that case actually gets called and starts in a trial, that file can be transferred to any prosecutor, because we're all deemed to have the same qualifications and the same ability. So cases can move up until the moment I stand up in court, the jury is sworn, and the case begins. I think just very briefly on plea bargaining and the stage at which that can happen. I think in the UK, the general approach is it can happen any time, even up until the trial starts. Once the trial starts, the only basis on which I might accept a plea is if my evidence doesn't quite come up to scratch. But if that situation has arisen in the middle of a trial, I'd be very surprised if a defendant came and offered a plea at all. I mean, he's winning. The difference in the UK, I think, is we can't guarantee, a prosecutor has no say in the sentence. We can't say to a defendant, plead to this and you'll get 5 years. If you don't, I'm going for 25 years. That decision is ultimately up to the judge. And it is only in the Crown Court, where you have jury trials, that we can even seek an indication of what that sentence might be. So it's a little bit different, I think, from the US in terms of the role of the prosecutor in accepting a plea. And we always have to do it on the basis of, does the evidence justify accepting a lesser plea or a different basis of plea? He says 1 punch, we said 2 punches. Do we want to go to trial over that? Probably not. So we might accept a basis of plea that it was only 1 blow instead of 2. And finally, on the standard of proof beyond reasonable doubt. Beyond reasonable doubt is what the court has to apply. Okay, that's once the trial starts, the court must be satisfied beyond reasonable doubt that this defendant is guilty. But the point where a prosecutor is making a decision to charge, which, remember, is a paper exercise. We don't know what these witnesses are going to sound like. We don't know how good they're going to come across. We don't know what this evidence ultimately is going to look like at court. The standard is actually lower. A prosecutor must simply ask, is it more likely than not on this evidence that I'm reading through and looking at right now, is it more likely than not that I'll get a conviction? But once they get to trial, that standard goes up, it's beyond reasonable doubt, and that is something for a court to apply. Okay?
So much of what Sharmini said about the UK applies to the US, so I'm only going to talk about the differences. In terms of plea agreements, we can actually negotiate plea agreements before charge, after charge, up until the end of the prosecution's case, through to the end of the defense's case, and even while the jury is out deliberating, or if it's a bench trial, the judge is out rendering his or her decision. The requirement under law is that once a decision is rendered, once the jury has come back with a verdict or the court is ready to issue its decision, then you're no longer able to engage in plea bargaining. The reality, though, is the earlier that an accused person agrees to plead guilty, the more likely they are to get a more lenient sentence. So a judge is likely to give a higher sentence if you wait to bargain with the prosecutor until the end of the case. And that's just the reality. So plea agreements do operate a little bit differently in the UK. There's a lot more latitude that allows us to negotiate at a much earlier stage and all the way through. And just to give you an example, we can actually negotiate with the suspect before they actually get arrested. So they can be a target of an investigation, they can get an attorney, and we can negotiate pre-charge. So they come into the system, they know exactly what their charges are going to be. We have a plea agreement with terms that are already set. So that is a real added benefit because we can get that case through the system as quickly as possible. As Sharmini said, reasonable doubt is decided by the court. In the U.S., the majority of our cases are ruled upon by juries. So juries are given instructions about what reasonable doubt is. I want to clarify that for federal prosecutors, we always assess the evidence at whether or not we have proof beyond a reasonable doubt, because we're not going to charge a case if we know we can't get that conviction at the end. So we do have a slightly higher standard and responsibility on our ends. In terms of investigators, there are much higher levels of requirements to become a police officer. In most jurisdictions, you got to have a degree, and you have to go through some sort of police academy or institutional training, which takes several weeks, if not several months. And that's the same whether you are a local police officer, a state police officer, or a federal police officer. One additional component that I think is critically important is continuous training. So there's continuous training of police officers through either the police departments or through prosecution services that come in to train. If you are working in a specialized unit or you try to go to the level of a detective or a sergeant, there's other layers of training and some certifications that you have to go through. One of the things that I think is critically important is that there's always training between prosecution services and police departments. Critically important. So that as new laws are being made, new rulings by the court are coming out, that information is being shared with police officers. So I think that's critically important. Someone asked about stories from Kenya on the decision to charge. So I have had the pleasure, as with the U.S. Department of Justice, we've worked very closely with the Office of the Director of Public Prosecution and IJM on the intake process, and we've started doing observations of actual decision to charge that's happening on the ground. And I will tell you that it's working. One of the things that I think has stood out to me, observing here on the coast region and observing intake in Nairobi, is that the police officers are coming in with files. And they are coming in and they're asking questions. and they are asking whether or not there is sufficiency to charge and asking for instructions. They are getting instructions on what else is needed. They are taking the advice about what should be charged or what should not be charged. And it is really a coordination that is really effective. And I think that has a lot to do with the relationships on the ground that are being established between the prosecutors and the investigators. And I will tell you that this is a learning process. It's not going to change overnight. It's something that the ODPP is very focused on in improving that process and in improving that coordination. But I will tell you, just off of some of the initial observations that USDOJ and IJM are making in various places here in Kenya, it appears to be working, and I think it's going to get better and better over time. And then just quickly on the media coverage, very similar to the UK, but I do want to stress in the US, the media can comment. They do that quite a bit. But my role as the prosecutor is not to interfere with that process. Our freedom of speech, freedom of the press right is very strong in the US. I am limited, prosecutors are limited in when they can talk to the media. So similar to the US, when we indict a case or we arrest someone, we usually issue a press release, or there could be a press conference where information is shared. The information that's shared with the media always is limited to what's in the public sphere. So we're not allowed to talk about anything that is not in the public sphere. That is the reason why at the federal level we have what we call speaking indictments. We put a lot of detail in our indictments about what the evidence is, and that allows us to talk about it to the press.